Representatives Bricken, Carter, Eldridge, Gillespie, Harris, Stewart, Chairman Littleton. Madam Chair, you have a quorum.
Awesome. Is that a little better? Welcome, everyone. Do any of the members have personal orders or anything they'd like to talk about? Hearing none, we'll move on with the, first off, we have a few bills that have been taken off notice by sponsor's request. Number 2, 1104 by Representative Shaw is off notice by his request. Number 3, 1079 by Chairman Sexton is off notice. And number 4, 1502 by Representative Cochran is off notice. Do you want to go ahead and do the special calendar? Okay. So I guess we're ready to move forward with item number 1, 1377 by Chairman Crawford.
Second.
Properly motion and second. You are recognized.
Thank you, Madam Chair Lady and Committee. Today I have House Bill 1377. This is known as Eli's Law. And to make a long story pretty short, basically what this bill would do is if a parent who has had a foster child or a child that has been removed by Children's Services due to neglect or violence or those type things, and they have a natural born child later, that this would require the Children's Services to notify the judges.
Chairman Crawford, I believe some of this is in the amendment. We need to get the amendment on, please.
Okay, the amendment I have is 6702.
Is that the one you want to go with?
Yes, ma'am.
Okay. Properly motion is second. Do you want to describe the amendment, or does it
Yes,
make the bill?
basically the amendment is just changing the word from shall to should.
Okay. All those in favor of putting amendment 6702 onto House Bill 1377, say aye. Aye. Those opposed, no. The ayes have it. Bill is amended.
Okay. All right, and so this would require them to report to the judge so they can check on the other child to make sure that it is not being neglected or mistreated in any way, as long as the other child is still in protective services. I do understand Chair Lady has a bill that kind of we're on the same lines with this, and so I'm possibly we'll see if we can get them grouped together, and instead of running two bills through the House, I'll probably sign on to hers, or she can sign on to mine, or whatever, to keep y'all from having to deal with two bills. But basically, that's what the bill does as amended.
We'll work together on that, but I do appreciate you bringing this. I've worked on this for years, and this is, it's a beginning, a very good beginning, I think, and thank you for bringing it.
Yes, ma'am, thank you.
And whatever we need to do with it, we'll talk about that.
Yes,
So,
ma'am.
Are there any other questions for Chairman Crawford? Are we ready to vote? Hearing no objection, all of those in favor of House Bill 1377 as amended, say aye. Aye. Those opposed, no. The ayes have it. You move out to civil
Thank you, Madam
rule.
Chairman, and thank you,
And
Committee.
thank you. So item number 2 has been taken off notice. Number 3, House Bill 1079 is off notice, and item number 4, 1502 is off notice. That leaves us with Chairman Weaver. I don't see her. We'll roll her to the bottom of the hill. And next, we're going to go out of session and pass the gavel to Representative Brigham.
We have House Bill 1268 by Chairman Littleton.
Motion. Second.
All right, Chairman, you are moving forward.
Thank you,
with
Mr.
amendment.
Chairman. It does have an amendment, 6241.
We have a motion second.
Motion.
All right, the amendment is properly motioned. Does the amendment make the bill?
It does.
All right, let's go ahead and get that on the bill. All in favor of Amendment 6241, say aye.
Aye.
Any opposed? The amendment's on the bill. They're talk about the bill.
Right. Thank you, Mr. Chairman. This bill says that the Department of Children's Services shall notify the appropriate court when the department has knowledge that a foster parent from a kinship placement violated a court order by allowing a child to visit the child's parent within 30 calendar days of the department's knowledge of the information. We see from time to time that the kinship has the child and the parent comes back and it's supposed to be on supervised visitation, and the next thing you know, the child is with the parent and back into the world that it came from. So we're hoping that this will help solve that problem.
Very good. Any questions to the sponsor? Seeing none. All in favor of adopting House Bill 1268 and moving on to civil justice full, say aye. Aye. Any opposed? Bill is approved. I'm going to gavel back out and hand it back.
Thank you, Vice Chair Brickham. We are back in session, and next up, we have item number 5 of House Bill 1545 by Representative Weaver. Properly motion and second, you are recognized, Chairman Weaver.
Please, is this 1547 or 1545?
45.
Okay, thank you. Give me just a minute here. Many of us are all over the place today, so. Okay, so what this bill seeks to do is authorize a family who is party to a juvenile court proceeding resulting from a report or investigation of harm or abuse to request a family advocate to serve in the interest of the family reunification and family support. The mission of this bill and the heart intent of this bill is to do all we can to get children with their families. And I know that the governor has said numerous times that he is on a mission to have Tennessee be a leader in foster care or in adoption. And I know that it's the intent that we want these children to be in stable homes. What's happening is we seem to have, some issues out on the field. Now, I'm just now getting educated on it, so bear with me here. But I did find out that Smith County has some serious issues with putting children in foster care, and I'm we're one of the leaders, and I don't necessarily want to be known for that. So what can we do to help the process? And what this bill seeks to do is to say, okay, let's have a family advocate or a volunteer in place to, help parents and the departments and the court procedures, because basically parents, they feel that it's very adversarial for them. And of course, a lot of cases, you don't have a lot of, there are not good parents. You're going to have that. In my situation in Smith County, there is a lot of drug abuse and neglect. I know of one child that our little core group meets on a monthly basis, and he's a 14-year-old. Well, he's 16 now.
Chairman Weaver, I forgot that you do have an amendment that we need to put on the bill.
Excuse me. All right, thank you. Thank you for helping me get this in the right posture. That amendment is let's see. Good grief. Hey, can you give me the number? Oh, wait, here it is. That amendment is 6728.
That's correct. Okay. So we need to put that on the bill. All those in favor of Amendment 6728 going on to House Bill 1545, say aye. Aye. Those opposed, no. The ayes have it. You're recognized on 1545 as amended.
Thank you, Chairman. Thank you very much. So so what we want to do is we're asking that we can have a family member, and may I insert something as well? This is subcommittee. I want to ask if it's okay with the committee. I don't know how those proceedings will work. I'm going to be at the will of the committee. But there is a word that did not get in this amendment that I would like to add to. And I'm cool with maybe we'll add this amendment, and then with knowing that we've got another word to add to this when we come back into full, and then we can correct it then, however you want to handle that.
So you have another amendment?
No, I would have, because I'd have to add, I don't know if it's a verbal amendment, if it qualifies as that, but I'd like to add the word a family or advocate. After member, a family member or advocate. And the reason why I'm saying that is that sometimes family members aren't available. And so you have to rely on somebody that is there for the best interest of the child. And so I did not notice this, Chairman, in all this rush of what we're all doing. And I think it's, if we don't have a family member per se to be there, then at least we have an advocate. So that's what I seek to do, but I don't know if that would work. You tell me.
Well, we already have the CASA and the guardian ad litem. Are they not considered a advocate? in
No.
your eyes? What
No, because they
do you think?
oh, I'm sorry.
What are they considered then?
Well, as I understand it, a family member or an advocate or a volunteer or somebody that is there for just the best interest of the child. And they don't necessarily have that. The parents don't have that either. It's an adversarial for parents because, it's intimidating to them. Like I said, in some of the cases I know in Smith County, a parent might have some neglect. They're ashamed about it. As I was going to share with you about the young man that we have been kind of tutoring and mentoring. He didn't do anything wrong, and his family wasn't abusive to him. It's just they neglected him. And so right away, there's an adversarial vibe going between the department, DCS, and that parent. So if we had somebody in there that was a volunteer that could help and make sure that the parent's getting assistance and training and knowing how to be a better parent, then it's helping DCS, and it's actually helping these kids get reunified with their family. So that's why I wanted to put that in there.
Well, we do have CASA, and they are volunteers. Do you have that in Smith County?
Yes, we do have CASA. We do.
Well, they are volunteers, and they can go in the courtroom with the child.
Well, how about if we just pass what we have here? I'll discuss, and we'll see if there's something we need to do between now and full, and just add this amendment and then go from there. Would that work?
Well, this is just my opinion. We're at the will of the committee, but taking the liability away from the presumed, the family member, I'm not, what is your intent with that?
I got an idea. Can we go out of session and we bring somebody to the table that is a whole lot smarter than me on this? My passion and heart is for the child and for reunification. That's all I want to do. I want to have that happen as smoothly as possible. And I don't want to see Smith County, my home county, have more children put in foster care than any other county in the state. So can we do that?
We can. Without objection, we're out of session.
Thank you.
And I guess we'll call it Connie Regular. And could you state your name and who you're with for the record, please? Yes, and you have 3 minutes.
Okay, thank you, that's fine. So I am an attorney who's practiced law throughout Middle Tennessee for about 30 years now, and have really kind of focused on working through DCS cases throughout the whole state of Tennessee. So I've been up to Tri-Cities, I've been to Memphis, I've been all over, and I've also kind of made it my study and my passion to really understand how this system works. And what we have is an agency that was created in 1994 with the public policy of family reunification. And I know a whole lot about the funding, the federal funding, the Title IV-E. I've been to Washington, I also lobbied for the Family First bill there. But what we have is we have federal funding under Title IV-E that the state has to put the kids in foster care to do services, and it tended to put some kind of pressure the agency more in getting the kids into the foster care system. So what I have watched and what I have asked, I came to Representative Weaver to do, is to have a family advocate for the family. What you don't kind of understand probably from where you're sitting is that there's a parallel system that goes on once DCS becomes involved. There's the court system, and then there's the administrative system. So even though there's a guardian ad litem, which unfortunately is also adversarial to the parents many times, the CASA worker, who is often adversarial, and also their focus is under child safety and not necessarily under a family reunification. So this is to give the parents support, encouragement. We have a lot of times, and I know DCS comes up here every year and asks for more money because they're overburdened. They have to reduce their caseload. And so, Commissioner Nichols talked about the high turnover they had and how that could cause hiccups in the smooth running of the system. So to have somebody who can come in, who's willing to be educated with 10, 12 hours of just understanding the policies of DCS, understanding that if a parent's required to get a drug test, how to follow through with that, really kind of holding the hands of the parents. And we don't have that. And also, besides that, sometimes you will end the court proceeding, and let's say the parents do have a substance abuse issue and they admit to it, and there's an adjudication of that. After that, they still have an opportunity to reunify, but there's nobody involved now. So they no longer have an attorney to kind of work and assist them. And I've actually kind of taken this role with parents, even though I'm an attorney, because I want to see stronger, healthier families in Tennessee. And I have noticed that when I take that extra step of really advocating for them, helping keep DCS on the right track, asking simple questions like what is the barrier to reunification in meetings, that we have a lot more success. So I want Tennessee to be very successful, have stronger, healthier families, and make sure that children are in healthy, safe environments. And so I'm just asking for that. I am asking that it not be limited to a family member.
Yes,
Yeah.
thank you.
Thank you.
Well, I have a question, and we'll have to open up to the committee and see if they have any questions. When you said CASA is there for the family safety and not for the unification, well, the child and the family safety is important.
So child safety. So their focus is on child safety, and they investigate for child safety. But they don't advocate for the family and the parents, who really are standing side by side with the parents.
But they are inside the home.
Well,
They
they're
do
very
visit.
limited. Often they do not attend the administrative hearings. They're kind of outside of that. And really, it's they're called child and family team meetings. They are really the forum where the parents have to be helped, guided, assisted, and that's not CASA's role at all.
No, but it is for the safety of the child.
Yeah, like I said, they investigate for the purposes of preparing reports for child safety.
Okay,
Yes, ma'am.
Thank you. Are there any questions for Ms. Regular? Vice Chair Brookham, you're recognized.
Thank you, Chairman. Did you say you're here to advocate a family advocate?
Yes,
Okay.
for a family advocate, for the bill to be passed, and it says family member or there. We do just need to be able to extend that. I asked Representative Weaver to say family member or an advocate, because it shouldn't be limited to a family member.
This still might be the question to the sponsor. If the court, if they decide a family member, fine, I think the bill, but if they decide that it just needs to be another, what's the qualifications of that party? Does that party have to be trained to be an advocate? or not?
Well, yes, the preference is that there's a training, and I've outlined basically the sessions to educate them on the sort of just understanding the process. But honestly, just on a day-to-day basis, these parents just need an attaboy. They need encouragement. I mean, so they need somebody to kind of help them and to help them ask the right questions. So yes, we will, as Family Forward Project, which is what I advocate. I have an advocacy group. I have 15,000 members across the U.S. and about 1,000 of them are in Tennessee. So yes, we will help in that area. I do want to address your immunity issue if you want me to, but.
Chairman, just a follow-up question. Will CASA, are they on board with this bill, or it's going to run, are they going to get a conflicted message that they're secondary to this advocacy or not?
No, I don't believe, I'm sorry? Okay. I don't believe so because again, CASA comes in, CASA gets appointed. They're really an investigator of the circumstances that exist at the time. So they investigate that, they write a report on that, they do visit with the family, and sometimes they come back and do a follow-up visit with the family. But they're not the ones who are helping the family make sure that they get to parenting assessment. Their role is actually fairly limited, and it doesn't conflict with what they do.
Just hopefully one follow-up question, just because I'm not that familiar with the process. Would a judge issue, if this passed, could issue a ruling or that would appoint CASA as an advocate and a family member as an advocate?
Yes, a family advocate, yes.
No, I just want to click
Yeah.
here. Could there be more than one advocacy appointed by the court?
Yes, this does not interrupt the CASA appointment.
Thank you.
Representative Harris, you're recognized. Good. Any more questions for Ms. Regular? Seeing none, we'll be going back into session.
Do you not want me to address the immunity issue? No? Okay, thank you.
We're going to call up DCS now. Drew Wright, please, if you could come forward. Just state your name, who you're with for the record, please.
Thank you, Madam Chair. Drew Wright with DCS. Madam Chair, members of the committee, thank you for giving me the opportunity to speak. We have had some conversations with Representative Weaver about this bill. Shared with her some thoughts about the way it was originally drafted, and want to kind of share a concern about the addition of the word advocate to the amendment that's before you, because we discussed the amendment that's before you, and I will tell you that DCS's position on that amendment would have been deferred. We've got some concern with the advocate word being added. We've heard also from the juvenile courts about some concerns there too. I don't know if anyone's here on their behalf, but there's a lot of ambiguity as to what that would look like. There's not any evidence-based practices for that. There's not been any pilots. I think there's some staffing and resource concerns for adding an advocacy program that's not clearly spelled out and onto the burden of counties who are already stretched very thin, especially small rural counties. Their juvenile courts resources are very small and thin. But as far as DCS is concerned, the advocacy part, and you've heard some reference to investigations and different things, we very much care that our investigations would not be interfered with, and that was our primary kind of reason to look at this bill so closely. Again, with the amendment before you, allowing a family member to kind of advocate for a parent in that limited capacity, it wouldn't be concerning, but opening up to an advocate and not having the word advocate defined in any way and what that looks like, and not having any expectation of what it would do, if it's a person that's trained, if not trained, attorney, not attorney. They already have attorneys So it seems to get into some muddy waters. I say that very respectfully to Representative Weaver. She has been very willing to talk to us, and I appreciate what her passion and what she's done. I thought we were on working towards a different amendment. So
Well, thank you for being here. I failed to thank Ms. Regular for coming in today too, and for your remarks. Thank you for being here. I think my question is, other than, can a family member go into a judicial hearing that's supposed to be confidential? I mean, how would we work on that?
So the court could appoint this person with the consent of the parent. So the parent would have to consent to that person joining in that role that's outlined in this amendment. So the parent would consent.
Are there any other questions for Mr. Wright? Representative Stewart, you're recognized.
So did I hear you correctly that if the term advocate was not included, so it's just a family member, that the department would not be opposed to the bill? Or what's the exact posture of the department?
Thank you, Representative Stewart. Yes, sir. That's exactly what I tried to say. I didn't probably say it very articulately. The amendment 6728, as it's worded, the department would be deferred with that amendment.
Representative Stewart.
But now you're not, because we just amended it, is what you're saying? Or if we amend it, you will not be. You will be
Mr. Wright.
opposed to the bill. Is that fair? Thank you, Madam Chair.
Mr. Wright.
If it's amended to add the word advocate, I honestly don't know what our position would be. I think that it would highlight some of the concerns that I raised. I heard the testimony from the previous speaker seemed to speak to some broad categories of things that we would want to be careful about.
Thank you.
Are there any other questions for Mr. Wright? Hearing none. Thank you. With that, we will go back into session. Representative Weaver, you're recognized.
Thank you, Chairman. Thank you, Committee. Again, that's what I love about subcommittees. We get to flesh things out, and we get to discuss it and see what's the best way forward. I think what I would like to do, I'm at the will of the committee. We have amended the bill to prefer, which was the last one, 6728. Can we go ahead and put it in its proper posture and to move it out? If there's something that needs to come, I'll work with the department before we get into full. If not, we'll just pass it as it is. Would you be open to that?
Well, I need to know how we would get this parent or family member in the courtroom. Is that in this bill, in the amendment somewhere?
It says it authorized at any stage of dependency and neglect. I gotta put my glasses back on just a second. At any stage of a dependency and neglect proceeding, a court, with the consent of a parent who is a party to the proceeding, may appoint and authorize a family member of the parent to be present at all court proceedings and serve as an advocate for the parent in the interest of family support and reunification. The family member may testify before the court and is presumed to be acting in good faith and is immune from the liability that might otherwise be incurred while acting in good faith and within the scope of the appointment. That's what the amendment reads.
We're going to go out of session and ask legal about what we would have to do for the proceedings to get a family member into a confidential hearing.
Shirley.
Okay, so we are out of session for legal. You are right.
Michelle Fogarty, Legal Services. Juvenile proceedings are confidential, and so all of the respondents in the dependency neglect action, I believe, would have to consent to have this person present during the entire proceeding.
Chairman?
So does it not say with the consent?
We are back in session, sorry.
Oh, sorry. Does it not say with the consent in that language?
It says with the consent of a parent. So I don't know if there might be a dependency neglect that has both parents as respondents. I don't know what, the bill doesn't contemplate if one parent agrees and one parent doesn't. I think that would be up to the court.
And I think you just said the bingo word, it's up to the court. Would the judge be able to do that? Would they be appointing?
Do we need to go back out of session? Okay, we'll go out of session for legal. You're recognized.
Michelle Fogarty, Legal Services, all of the language of the bill is that the court may appoint. But I'm not sure I understand your question. If there are two respondents to the confidential proceeding, and if one does not consent, then I'm not sure, there's no provision in this language as to what would happen if one parent doesn't consent to having a family member present for the entire proceeding. Because you have witnesses, in a court hearing, witnesses are usually excluded from the courtroom except for while they're testifying.
Chairman Weaver.
Thank you, Chairman. I'm just trying to figure out how we can make this as simple as possible. I'm not trying to create,
Excuse me.
A difficult-
I thought you had a question.
yeah,
Ms.
for the,
Fogarty.
yes, for legal.
Okay.
I'm not sure, you're the lawyer, you're the legal one. How can we move forward here in the best interest of what we're trying to do to get an advocate to be involved?
Ms. Fogarty.
Michelle Fogarty, Legal Services. I can't give you policy or opinion recommendations. I can only answer legal questions on the language in the bill as before us.
Chair Lady Weaver.
Thank you for that. I'm done asking you questions then.
Any more questions for Ms. Fogarty? So we will go back into session. Are there any other questions for Chair Lady Weaver? Vice Chair Eldridge, you're recognized.
The statement you just made a minute ago about making it as simple as possible, this don't look simple. To me, I mean, I may be wrong, I'm not an attorney by any means, but just sitting here listening to the people that have spoke and everything, this doesn't seem simple to me. And it seems like that it goes a lot deeper than just, just having a family member. I mean, getting a family member that either one or both parents are going to agree to. I mean, if there's a problem in that family, who are you going to go to? I guess that's my question. Who would you ask to be that advocate going into there for the family? I guess I just don't understand that, but maybe.
Chair Lady Weaver.
May I make this suggestion? Allow me to get with the department, and if we don't come up with something that the department can agree to and be okay with, then we don't go anywhere between now and next week. Would that be something I could offer?
This is our final calendar today.
Oh, that creates a problem. Well,
Vice Chair Eldridge.
I think it needs to be looked at, definitely, and I don't know if you'd be open to some type of a summer study for it or what, but I don't know if that's agreeable to you or not, but it just, I think it needs to be looked at more, definitely, but it's just not, to me, it just don't sound simple.
Chair Lady Weaver.
thank you for those comments. This is what happens. Again, I love committees in the House side. May I offer then, can you roll it to the next calendar of next year? I'll get it fixed. We'll work on it. We'll come back next year. We'll have clear and concise policy in place that everybody can feel comfortable with. Would that work?
Vice Chair Eldridge, was that a motion or?
I'll make the motion for the first calendar of next year.
Second.
That's fine. That works.
Without
you, Chairman.
objection, but I do want to say that I think it's a great start, but there were some of the things in the amendment that just didn't add up for us, so, but it's a great bill, and I'd like to work with you on it myself.
Thank you so much. Thank
Yes.
you. Thank you. Thank you, committee, for your indulgence.
Thank you. So next we have item number 6, House Bill 1547 by Chair Lady Weaver.
Oh, boy, double dose.
Motion.
Properly motioned and second, you are recognized.
There was an amendment that was put on, and I need to make sure that you have that, the Senate put an amendment on it. That number is Senate Bill 1337. Do you have that before you?
We do not. It didn't come to any of us.
Well, that creates, and this is the last committee. All right, then. I guess I'm done.
Do you,
I have the amendment here that basically would,
hold on one second, please. We're going to go out of session for
okay,
just a second.
thanks.
He's going to get a copy of the amendment. Can we look at yours? Here's the pen. She has it, we don't. Let me ask. What is the drafting code of the amendment? We're going to look at it. We have not seen it.
It is Senate Bill 1337 by Senator Bell.
But the amendment number, the code for the amendment, please.
6387.
We're going to go back into session, and we're going to take a brief recess and read the amendment.
Okay,
And then
thank
we'll
you.
vote on if we're going to accept it or not.
Okay, thank you.
We're in recess. Yes, please. How do you do that?
So it said if DCS cannot require immunizations for adopting or foster parent if the child is under, unless the child's under 18 months or has a significantly documented medical needs.
We're going to go back into session, and I think all the members have read the amendment, and if there's no objection, we're going to add on the accept the untimely amendment. So if you would like to explain that, please, Chair Lady Weaver.
Motion on the amendment. Second.
Properly motioned and second.
Thank you, Chairman. Thank you, members. You're so gracious. The amendment deletes and rewrites all language after the enacting clause, and it prohibits DCS from requiring an individual or members of an individual's household to undergo an immunization as a condition of adopting a child or overseeing a child in foster care unless the child is under 18 months of age or has significant documented medical needs that would necessitate the caregiver or members of the caregiver's household being immunized. So that's what the bill does. That's the amendment, excuse me.
Are there any questions about the amendment? Representative Harris, you're recognized.
Yes, so I do have two questions just for the record, but they're for DCS, not for the sponsor. If we can go out of session. If we can go out of session, so ask DCS two questions.
Absolutely. Without objection, we're out of session. If you would come forward and state your name and who you're with.
Chair Lady Drew Wright with DCS. I brought some reinforcements with me. Jocelyn Young, DCS. Happy to address Representative Harris's questions.
You're recognized.
So with this amendment, you all at DCS are okay with this amendment?
Mr. Wright, you're recognized.
Yes, sir. Representative Harris, on Amendment 6387, we worked with the sponsors on this and are deferred on this amendment.
And the second question,
Representative Harris.
sorry, thank you.
Recognized.
And on the second question, if this happens, the child still gets their immunization, even if the parent does not, the foster parent does not, correct?
Mr. Wright.
So, yes, you're talking about the infant because?
Yes.
Sure. So to answer your question, yes.
Thank you.
Are there any other questions? Representative Stewart, you're recognized.
I think you're going to elaborate, so who's not getting, once you, I know you know what you're going to say, why don't you explain?
Mr. Wright.
Yes, sir. Happy to do that. So this bill sort of speaks to a foster parent and an adoptive parent and their family members have to be adopted. Excuse me. It's been a long day for all of us.
All of us.
Have to be immunized. And what we're talking about, just so we're all clear, is pertussis and influenza vaccinations. That's all it requires. The family members who could be children would have to be vaccinated as well. This would, our policy currently says 5 years. This would basically force our policy to change to 18 months. And that's, I think, what the crux of it is. So when asked about the children being vaccinated, I was careful. The children would have to be vaccinated if the other children in the family would have to be vaccinated if the foster or adoptive family were to take an infant less than 18 months of age. And that number sort of speaks to the immunization schedule is seemingly fairly well complete by 18 months. Past that are boosters. So this seeks to protect the infant who hasn't been fully vaccinated until 18 months from any unnecessary harm that could.
Representative Stewart.
Thank you.
Are there any other questions for Mr. Wright? Thank y'all very much for being here. We're back in session. So we're ready. We're on the amendment.
It's been a long
So
day.
all those in favor, I don't even have the number, of amendment
6387.
6387, going on to House Bill 1547, say aye. Those opposed, no. The ayes have it. So you are on House Bill 1547 as amended, Chair Lady Weaver.
Thank you, Chairman. Thank you, members. You guys are amazing to work with. I just want to close in saying that I remember our governor making a comment at the beginning of the year that, and I'd like to just read his quote. He says, "When we join forces with the faith community and trusted partners like Tennessee Kids Belong and Show Hope, we can help Tennessee foster kids find permanent loving homes. I am calling on the faith community to join us as we work to build one of the most adoption-friendly states in the country." This bill moves the needle and seeks to help loving, caring families in the state of Tennessee adopt children. And that's the goal here. We want to find permanent homes for these children and get them in an environment that is stable and secure. With that being said, I appreciate this committee. I know your heart and your passion is to help kids too, so I appreciate that as well.
Thank you, Chair Lady Weaver, and I think we're all on the same page.
Yes, we are.
We want to save them all, but if we can do it one at a time, that's how we're going to do it,
Yes.
right? Okay, thank you very much. So are we ready to vote on House Bill 1547? Everyone in favor, say aye. Those opposed, no. You move out to civil pool. If you want to be recorded as a no, please see the clerk. Thank you. Thank you. So now we're going to the. So now we're going to take up the special calendar, which is number 1, House Bill 1164 by Representative Harris. And we're going to refer that to the desk at your request. Is that correct? Without objection,
We're pulling that off notice.
House Bill 1164 goes to the clerk's desk at the, per sponsor's request. Are there any other announcements today? Hearing none, I want to say thank you to everyone that's been on this committee. It's been a new committee. I think we've done good things, and we're all here for the right reasons, and I appreciate all your hard work. Representative Stewart.
Chair Lady, thanks for running a fair process. That always it serves everybody of both parties, and you definitely ran a fair committee, and everybody got to speak that wanted to speak, so thank you so much.
Thank you for saying that. Thank you very much. And we have a little surprise for you, Haley, if you could help us out here. We didn't get jackets or sweatshirts, but we got some cupcakes, so we all have a jacket and a sweatshirt now, so we can always eat a cupcake, can't we? But thank y'all very much for being such good members, and I've enjoyed it. So I guess I need a motion to adjourn. Oh, wait, we are closed to the subject of the chair.